Good morning and welcome to today's AFAN webinar. I'm Ian McPherson, founder and director of AFAN, and it's a pleasure to introduce Craig Ball. Craig, you've been working in estate planning for 25 years now or longer. What was the attraction to that particular area when you came into the business?
Mate, when I first started back in 1988, I really had no idea what I was doing. But more importantly, the impact that we have on the lives of Australian families. I was very raw, very green, but I experienced a death claim really early on in my career. And even though the proceeds were paid to the widow without too much drama, I asked myself a question: have I actually done the very best that I could for this particular family, or did I simply sell a product? And I was ashamed to say that it was the latter. And it was at that point, really early in my career, I made the decision to try and obtain, where possible, the very best outcome for my clients. And as soon as I started heading down that track, it dawned on me that families all around Australia were receiving large amounts of money from the proceeds of life insurance policies, and in many cases, millions of dollars. But what was bizarre was just how much of that money was being lost to the families because of different circumstances like relationship breakdowns, where estates were going through bankruptcy proceedings, or what I like to call Australia's hidden death tax. And I then thought, what's the point of providing a family with all of this money and then just simply watching the vultures tear the meat off the carcass? So that's essentially what sent me down this path.
Right. Yeah, I mean, it's one thing to get the payout, and it's another thing to have other people invited into the table to take a big piece of that. So what are the things you typically look for when you're assisting clients with estate planning needs?
Well, we might refer to some slides here. I think from my perspective, the very first step, I'll just get you to go through a bit further, please, Georgia, if that's okay. Yeah, the very first step is to identify exactly what the client owns. And you might just have to page down because it's not coming down there, Georgia. Yeah, so things like assets that are held inside a super fund, that's not going to go through the client's estate. Assets held inside a trust, jointly owned assets, these don't form part of the estate. So it's really important to identify who owns what. That's the very first step in the process. I had a telephone meeting with a client that was referred to me just the other day, and his lawyer was about to put in place a testamentary trust will. But after our initial meeting, we discovered that he actually doesn't have any assets in his name. All of his assets are actually owned inside trusts. So the testamentary trust would receive nothing basically when he passes. So that's the first step. Identify what the client actually owns. The next step is to make sure that all of the professionals are on the same page, because there's a number of professionals that need to be involved to ensure that you get the right outcome for the client. So the accountant is normally the first port of call. The accountant is normally the professional that's been working with the client for a long period of time, has possibly set up different structures for different purposes. Also working with the lawyer, making sure that any of the advice that the lawyer is giving to the client is on par with what you're giving, so that we're not going to undo some of the good work that the other professionals have done. Working with the financial planners as well, to make sure that we're aligned with them, and then finally the risk advisor. Now, in my case, I'm the fourth one on that page, but I like to sort of project manage the whole process and make sure that everyone is working together to get the right outcome. Someone's sort of got to step up to the plate and open the lines of communication between all the different parties. And if you do that, and everyone has a clear understanding of what we're trying to achieve, then the outcome that we can get for clients is really first class.
Yeah, and I guess you've got to engage these professionals early on in the piece as well. But can we take a step back? I mean, most people are familiar with assets inside superannuation. Most people are familiar with assets that they hold personally, but you mentioned assets held within a trust. What are the specific issues that people face with assets held within a trust? And for some other people out there who don't, use those sort of vehicles, what should they be looking out for?
I'll discuss that very shortly, mate, because that's a really good question. But what before we actually go on to the trust, we'll go back to just sort of a simple example of where it's really important that the different professionals are aligned. Let's have a look at, say, the accountant and the solicitor. Now, if we take the example of, say, Bob, who's a builder, and he has his own building company, Bob's Building Proprietary Limited, and he's married to Sue, and Sue might be working part-time in the business because she's looking after the kids as well, and Sue's doing the paperwork for the business, doing the invoicing, etc. Often what we see is where say in this example, where the husband is the business owner and the risk lies with the husband, often we'll see that the accountant will advise the clients to have their home, their principal place of residence, owned by Sue, owned by the wife. That way, if Bob and his building company get sued, they can protect the house. But often in this case, we find that the accountant will say to Bob and Sue, make sure you guys have got a will. So they'll go to their local lawyer, and the lawyer will just draft a standard will. Okay, now, if we go to the next slide, Georgia, the problem there is that we always sort of assume that the husband is going to pass away first. But in 30 years of doing this type of work, it's about 50-50. Often it's the wife that passes away. And so what happens if Sue actually predeceases Bob? So the house was in Sue's name, and it was placed in Sue's name specifically to protect that property if Bob was sued. But if they have a standard will, then Sue leaves the house to Bob. Now all of the work that the accountant has done has actually been undone, because that property is now exposed. It's exposed to creditors if Bob is being sued, and it's exposed to future relationships. And if we go to the next slide, Georgia. And this is what tends to happen, particularly with younger couples, is that if you lose your spouse, at some stage, you may enter into another relationship. So Bob lost Sue. He's looking after the kids. He has the home in his name. And then he meets Miss Wright. And the new lady in his life, she may have children of her own, but now they're all living happily together in Bob's residence, which used to be Bob and Sue's residence. If we just go to the next slide. But the issue that we've got is, if you have a look at the divorce rate in Australia, with first marriages, the divorce rate is actually 50%, but with second, it's 70%. Right? So, regardless of the fact that, Bob has lost the love of his life, we don't know what emotional baggage his new partner is bringing into this relationship. But given that we have such a high relationship breakdown percentage in Australia for second relationships, the chances of this relationship lasting are quite slim. Okay, so simply by the two professionals not talking to each other, we've put Bob and his children into a very unfortunate situation. Now, back to your question, Ian, about the trust. This is really important. And we'll just bring up the next slide, please, Georgia. When we have a look at trust, trusts are an entity for owning assets, and they're set up for different purposes. But there are a couple of different parties within a trust that are quite important. So we have Bob and Sue, they have a family trust, and the trustee may be Bob and Sue, it might be Bob, it might be a trustee company, Bob and Sue Proprietary Limited as trustee for the Bob and Sue Family Trust. And then there are beneficiaries. Beneficiaries are those who are entitled to consideration. But you'll notice a position up there which is in red. And this is the key position. And this is what we find is often overlooked. And this is the role of the appointor or the principal. Now, as I said before, assets that are held in a trust, they won't go via a will when someone passes away. So if Bob dies and he has an investment property in his family trust, if he dies, the trust still owns the investment property. But as you can see in this particular slide, Bob is the appointor. Now the appointor, that's the decision maker. The appointor can hire and fire the trustee. But we need to ask ourselves, if you just click on page down, please, Georgia. If Bob dies, who controls the trust? Has a secondary appointor been nominated? And where is that documented? Are they comfortable with the executor coming in to take on that role for a period? I had a meeting, it was a couple of years ago, with a fellow that was referred to me, a 72-year-old, and we looked at his estate planning requirements, and he was mentioning all throughout the meeting that he was leaving, let's call it XYZ Proprietary Limited, to his daughter. And when I asked him why he was doing that, he said, because XYZ owns $2 million worth of property. But when we looked at his will, it actually did state that XYZ Proprietary Limited and the shares in that company were being left to his daughter. But what we discovered when we did our searches was that XYZ Proprietary Limited was simply a trustee company for a family discretionary trust. And the $2 million property was held within the trust, not within the company. And when we looked at the trust deed, this chap was the appointor or principal, but the secondary appointor was his accountant. So if he passes away, the secondary appointor has control. And that's not the outcome that he wanted. So when clients have assets held in trust, we need to work with the lawyers and the accountants to ensure that any assets that are held in the trust are controlled by the right people should that particular individual pass away, if he or she has been nominated as the appointor.
Right.
So,
yeah, I mean, it's a really very important position that you need to work on. I've got a fairly lengthy thing that we workshop together in the office, so excuse me for reading it out, but I've heard you use the term making sure all the professionals are in alignment, and we're just touching on that right now. And your example before, the widower remarrying and then losing a percentage of the family home after the second marriage fails, is a good example of the accountant and the solicitor failing to communicate with each other. Or as the term you use when we're working with clients or workshopping is being out of alignment. Can you give our attendees another example of professionals being out of alignment to the detriment of the client?
Yeah, certainly, mate. What I see often, if we just bring up the next slide, please, Georgia. What I see often is a misalignment between the accountant and the financial planner or the risk advisor. So we'll go back to this particular discretionary trust that we're talking about. And this is a common structure that is set up by accountants for business owners. What we need to understand is what was the purpose of the trust. And if you just page down, please, Georgia. So the purpose of the trust may have been to hold particular assets, such as that investment property, and page down again, or it could be for income distribution. And this is often the case where you have, in this case, Bob's building company, and it might be Bob and Sue Proprietary Limited as trustee for the Bob and Sue Family Trust, trading as Bob's building. All right, but essentially, when Sue does her invoicing, the money is coming into the trust. And so the misalignment often happens in regards to the structuring of insurance policies. And if you just page down again, please, Georgia. And I often see it with income protection policies. The question is Bob going to be the owner of his income protection policy, or should it be the family trust? Now, remember, it comes down to the purpose of the trust. If the trust was put in place to distribute income to family members and minimise tax, if we have the income protection contract owned in Bob's name only, and Bob goes on claim, his personal taxation liability will actually increase. But by the financial planner or the risk advisor working in alignment with the accountant and understanding why that particular structure was put in place, we would then have the income protection policy owned by that discretionary trust. And at the point of claim, the insurance company would pay the proceeds into the trust. And even while Bob was on claim, he could still do the same distributions that he was doing prior to being incapacitated. So that's a typical example that we come across all the time.
So this particular area is obviously a bit of a minefield, isn't it? So, how do advisors and planners know what the right directions or the right indications are for their clients, or how they set up the nominations for structures like this? I mean, what's your advice to them about getting this right first time?
Yeah, it's really difficult because we need to understand all the different circumstances, and you need to understand what the client's outcome is and then work with the accountant, the lawyer and the financial planner to discuss the particular strategy. Too many times I see advisors just putting insurances in place, putting the insurances through superannuation and nominating a spouse as a beneficiary. And there's all sorts of problems when we simply do that. Okay, so let's look at Bob's superannuation. So Bob would have his own super fund. We've done some life insurance for Bob through the super fund. And then the next question is, who do we put as Bob's nomination? Who's his beneficiary? So number one, is it Sue? If we have all the money paid to Sue, then we need to ask ourselves, is that tax effective? Will those funds be protected? The answer often will be no to both of those. So having Sue as the sole beneficiary to receive 100% of the proceeds as a lump sum has a couple of problems associated with it. Number one is that Sue may use the funds to clear debt, but she has to replace Bob's income. So whatever the balance is of the proceeds, she needs to invest that, and the earnings will be taxed at her marginal rate. Now, that's one of the hidden death taxes that I alluded to before. Right? So how do we get around that? Do we pay it to the estate of Bob? The problem when we do that is, remember, Bob's a director, and if he and his company were in the proceeds of being sued, and all of a sudden a couple of $1 million hits his estate, regardless of whether there's a testamentary trust or not, the creditors could get their hands on it. So what about the kids? How do we pay it to the kids? Well, if it comes as a lump sum, how does that help Sue? Remember, they're minors. And, if all the money is sitting with the kids, how does Sue utilise that to, replace the income that's been lost through Bob's death? And if we're paying lump sums or pensions, do we pay these to Sue and the kids? And will it affect Sue's transfer balance cap, the new rule that was introduced on the 1st of July 2017? So there's a lot of anomalies there. And you can't just have a one shoe size fits all. You need to talk with the accountant and the lawyer to discuss the strategy. And the strategy is never a set and forget. It's got to be reviewed constantly. And if we go to the next one, it's exactly the same when we are doing Sue's beneficiaries. Who does she nominate as a beneficiary? Does she nominate Bob? Well, remember, he's the director. What about Sue's estate? That may be appropriate, but does she have a testamentary trust will? If she doesn't, and she has a standard will, who is she leaving the money to? What about the kids? Same issue. What about if we pay Bob a pension? Not only do we have the issue of his transfer balance cap, but we've got the other issue of increasing his taxable income by doing that. Okay, so it's a little bit complicated, and you need to pay particular attention, because if you just pay the money to the estate, you're probably going to get a really bad outcome for this particular client. If in doubt, talk to your technical people within the institutions, talk to the different estate planning specialists around the country, but more importantly, talk to the accountant and the lawyer that are either in your network or that are currently working with your particular client.
Mm. So it's apparent that your focus is on strategy and outcome for the clients, as indeed is everyone else who works for AFAN, which is a message that we're all hearing loud and clear from FASIA, ASIC, and the outcomes of the recent Royal Commission. So what do you, Craig, do to ensure all professionals are on the same page with the client?
It's about project managing the whole process. As I said, someone has to do it, and often I find that accountants are very busy with taxation and compliance. Lawyers are very busy as well. We're all very busy, but someone has to step up to the plate and project manage it. And it's actually very beneficial, not only for the client, but for all those involved, because they get an understanding of the sorts of outcomes that we can all achieve for the clients. But it just develops really strong relationships between the professionals as well. And if you are proactive in getting everyone on board and project managing, it's beneficial professionally as well, because those same professionals that were working with the clients will then call on you to help you with clients that they're dealing with.
Certainly. I guess, a few of the advisors and planners out there would have got a few shivers going through them when we were talking about the minefield of beneficiary nominations within the superannuation environment. I'm sure they're sort of recounting client situations, etc., where it hasn't been a great outcome. You're well known throughout the industry as the developer of the Allocator software. And for those who are not familiar with the program, can you give us an idea of exactly what this software does for you, and more specifically for the clients?
Yes, certainly. We've actually got a couple of screenshots of the Allocator, Georgia, if you wouldn't mind just bringing up the first one. Thanks. Okay. I'll take you to a couple of different points on this particular software. Now, a lot of the people who have registered today have seen this before, but for those who haven't, I'll just take you through slowly, and we'll work our way down the left-hand side. We'll actually start right down the bottom where it says debt to be extinguished. And this is a common conversation that we all have with our clients. And in my opinion, insurances should be there to serve a purpose. And one of the purposes is to get rid of debt. So in this case, we might have, Bill Thompson and Sue. They have two children, Alex and Bobby, and they've got a mortgage of $400,000. And we know that it would cost about $15,000, $10,000, $15,000, $20,000 for funeral costs. So that's essentially their debt. In our discussions with this couple, Sue said if Bill passed away and she was debt-free, she'd need about $100,000 of income. So that's the second arrow from the bottom, the family income required. And she wants that until the children have finished their school, their education, so about 18 years. And then on the bottom right-hand side, when we do the calculations, it shows how much life insurance is required to provide that level of income for that many years, plus eliminate the debt, $1.8 million. And essentially, the top arrow, the beneficiary allocation, is essentially what we're doing in this case is giving 22.1% to Sue as a lump sum to get rid of the debt, and we're allocating 77.9% as an income stream. Okay, so this is just an example. This is not something that we would necessarily do. This is just an example. If we go to the next page, please, Georgia. This page shows you the outcome of that particular strategy. Now, we'll take our eyes over to the right-hand side where it says, how much tax would Sue pay if she received a lump sum? We all know that a lump sum from super is received tax-free, entire lump sum. But back to my point of what is Sue going to do post Bill passing away? Number one, she's going to get rid of the mortgage. And number two, she has to replace the income. So the balance, which is about 1.4 mil, she needs to invest that into something. She could put it in a bank account, properties, shares, whatever. But she's invested that $122,000 of tax over 10 years, that's just simply the tax on the earnings of that investment. Okay, another example of the hidden death tax that I was talking about. On the left-hand side, if we paid a death benefit pension solely to Sue, she would pay over 10 years just under $74,000 in tax, which is a saving for her of about 48.5 grand. So that's an okay outcome. It's not the best, but it's okay. If we go to the next slide, the next option would be, rather than paying Sue 100,000, you can see that we're only paying her 50. And we've decided to pay pensions to the two children of 25 each. So there's the 100,000 for the family income. And as we all know, minors or cis dependents can receive death benefit pensions right up until the age of 25, so long as they're still financially dependent on mum or dad. Mm. The amount that each beneficiary can receive before a cent of tax is paid is just under $50,000, $49,752. So let's call it 50 grand. All right, that's every single year. The way that's achieved is we're doing a drawdown of capital and we're taking earnings. And when you pull the earnings out of a pension account, they're taxed at marginal rates. If you retain earnings within a pension account, the tax is zero. When we've got money sitting in our accumulation accounts, the funds are being taxed at up to 15%. But when they're in pension phase, the earnings are taxed at zero. So it's a really great tax effective option. Now, in this case, what we've done is pay Sue 50,000 and each of the children 25. And you'll notice that there's a 18% beneficiary allocation to Alex and 19.8 to Bobby. And the reason why there's a difference there is because Bobby's younger. So the term is going to be a little bit longer, 2 years longer. We can even it out if people want the children to receive exactly the same. But the idea is to be able to cover their costs while they're still dependent on mum and dad. All right, so we've split it 3 ways, but all we've done is use some guesswork here. If we go to the next page, we'll have a look at the outcome now. So on the right-hand side, once again, if we pay the money to Sue as a lump sum, on the left-hand side, what the difference is when we include the children as beneficiaries. So that's an even better outcome. But unfortunately, the ATO is still a beneficiary of that outcome. It's only $1,300 over 10 years, but if we can get it to zero, it's even better. So we'll go to the next slide, please, Georgia. And this is where we let the software do the work for us. So where that little red circle is, that's a tax effective allocation. And what it does is it goes through a series of different calculations and to determine the very best beneficiary allocation to maximize the income for the family and minimize the tax. We won't always be able to zero out the tax, particularly for higher income families. But for medium to lower, we should be able to do it 100% of the time. Now you can see with Alex and Bobby, the 2 kids, previously they were receiving 25,000. The allocator has actually suggested we increase their level a little bit and pay a little less to Sue. Now in saying that, when we set the pension accounts up for a widow or a widower and their children, the incomes are being paid from the super fund into a child's bank account. And the remaining spouse will be the trustee on that bank account. So if school fees come through for Alex, for example, then in this case, Sue would pay the school fees because she's the trustee on that account. She would pay the school fees out of that particular child's account. What's really key here, guys, is when you're using this particular strategy, the lawyer that you're using to structure the wills needs to be aware of this strategy. It's not such an issue if only one parent passes away, but in the situation where both parents pass away, the children will go to a guardian. And the question is, do you want the guardian to be the sole trustee on any bank account that is receiving income streams for a child. Our preference is to have a co-signatory, co-trustee on that particular account, simply to protect the monies. You know, once both parents have passed away and the child is living with another person, we don't know what the circumstances are with that person. You know, do they run a business? What's their relationship like? Is there ever going to be the temptation for them to dip their fingers into the money pot that's been set up for Alex and Bobby? And so the lawyers that are working with you need to be aware of this particular strategy so that they can structure the wills accordingly, so that we've always got that safety net under the family. Now, the allocator has said we're going to give Alex and Bobby a little bit more and Sue a little bit less, taking into consideration that Sue controls all the funds. Okay, if we go to the next page, there's our outcome there. Okay, we've eliminated the ATO as a beneficiary, but it's using the ATO rules. Okay, this is not some scheme that's been set up by us. This is based on the rules set up by the federal government and the ATO. We're just using their rules. And unfortunately, you know, whenever I talk about this to clients, most of them have never heard of death benefit pensions. Most of them don't understand how testamentary trusts work. And we really have an obligation to inform all Australians, because these tools have been around for a very long period of time and they should be using them. We should be using them. We should be understanding them. We just go to the next slide, please, Georgia. Now, I mentioned the higher income earning families, and this can be a little bit tricky, but as I said, back in 2017, the government changed the rules in regards to how much we can have sitting in pension accounts. If I set up a pension account for Sue today, the maximum I can have in her account from day one is $1.6 million. If Sue has one child or 10 kids, it doesn't matter. The maximum that we can set up across the entire amount of accounts is 1.6. So if she's got 10 kids, they're only going to get 160 grand each or something like that. All right. Now, if I set up 1.6 as a death benefit pension account for Sue, that's going to affect how much she can have in her retirement savings. It's called the transfer balance cap. So we need to be really careful even about setting up pension accounts for widows and widowers, because it will affect how much they can have in retirement. However, this is actually a good thing, because there are some really clever strategies that we can take advantage of in conjunction with the client's accountants and lawyers that can get fantastic outcomes for families. They can solve all the problems. All right, so just go to the next page, please, Georgia. Now you can see that we tried to get $150,000 of income into the family, and this red flag came up. And it's just a warning that says, if you do that, Craig, you're going to exceed the transfer balance cap. So do you want to override it? Do you want to work it out manually, or do you want the allocator to do a particular strategy for you? So the advisor always is in the box seat with control. And in this case, we've said, yes, let's retain the kids' pensions, but because we're working closely with the lawyer and we're setting up a testamentary trust for this particular account, this particular client, let's move the pension that we were going to pay to the spouse down into the testamentary trust. So if you go to the next slide, please, Georgia. And that's exactly what we've done. So we're not paying Sue any pension at all. Sue may in fact go back to work. What we're going to do is the amount that we were allocating to Sue, we're going to deposit that into the testamentary trust, and we'll work with the lawyer during the administration process to set all this up. We'll still pay incomes to the children, and we've actually gone a little bit above the 50 odd grand there. That's okay. We can fine tune this manually as well. But by putting all of Sue's funds into the testamentary trust, we actually give her a lot of flexibility. She can take time off work and be paid income. She can draw capital out, which is always tax-free. She can top up the children if they're not at their maximums. if they're beneficiaries of that particular trust, she could take lump sums out of that trust and make undeducted contributions back into her retirement account. So we haven't affected her transfer balance capital. So it actually gives a lot of flexibility. And you can do some really clever work here, particularly with the medium to higher income families, by getting everyone on the same page, by including the financial planner, the risk advisor, the solicitor, and the accountant. And everyone's doing their part to get the right outcome. And you can see on the far right-hand side, there's an arrow, and the allocator has actually minimized the income in this situation and kept the pension sum under the 1.6. So with Alex and Bobby, if you add up their pension accounts, Alex has got 760 odd thousand and Bobby's got 839. You add those two figures and we're under the 1.6. Okay, so that's the power of this particular software. And when you go to the next page, it'll show you the outcome for this particular family. And as I said, in some circumstances, we can't eliminate all tax, but we have saved this family $115,000 in tax simply by using this particular strategy. And in fact, I think, we could even wiggle those figures down a little bit more, bring the kids' levels down and direct more to the testamentary trust and get that right down to zero. That'd be a fairly easy process, but that's the sort of results that you can get not only by using software, but by including the other professionals in this particular strategy, in this particular process. And the one thing it does is, once you've done your work, this type of work for a particular client, at some stage they will encounter another financial planning or risk professional. They're bound to run into them. There's always a temptation that particular professional is going to offer their services. But if they're not using this particular strategy, the clients just never leave. They're not going to leave to save a few dollars on a particular product when they know that the particular risk professional or financial planner is not giving any consideration whatsoever to the outcome. They might save $100 on an insurance policy, but it'll cost them $100,000 in tax when there's a claim.
And that's a significant sum, right? So this is the culmination of getting the right advice, using the right professionals and having everyone aligned in the client's best interest, and you can achieve outcomes like that. And stop inviting the tax office into your money in a legal way, well, which I'm sure everyone wants to do.
They're not going to tell you about it. How often have you seen the tax office advertise for these particular strategies to inform Australian consumers that they can actually use the tax office rules to reduce their tax liability? Yeah,
to not pay the tax office. It's a great example of that. Now, look, obviously this level of expertise doesn't, happen overnight, and every advisor isn't going to go out there and try and build their own platform like this to try and optimize stuff. Before we get to questions and that sort of thing for the attendees, what advice have you got for the, the estate planning community out there before they go down this path for the first time?
Firstly, it's not complicated. And I think a lot of people sort of steer away from it because they think the process needs to be complicated. It doesn't, and you don't need to know everything. If you just click down, please, George. I think the first thing is engage a mentor initially. Seek out someone in your area that has experience in this particular field. And then surround yourself with really clever professionals. I've got some great professionals in my network who are so have such a high level of expertise in this field, and I love sitting in on the meetings with them because I learn so much just by sitting in and understanding the complexities of the work that they do. So it takes time to build that particular network, and early on, you might need to sack a few. I've actually sacked a few lawyers and accountants over the years because, like any industry, there are some really good ones and there's some really bad ones. Be proactive. Too often we see situations where a risk advisor or a financial planner, so too often we see situations where a financial planner or a risk advisor has said to a client, oh, go and get a will. And then when they do the review 12 months later, they ask the client, did you get a will? And the answer is no. So we know that, many of us in Australia are pretty apathetic. That's just the Australian nature. So you have to be proactive, and we actually have it as part of our process. When we're recommending a particular strategy, part of the process is to bring the lawyers in to do the work. So our staff will actually work with the staff from the legal firms to set the appointments up for the clients. And I think that the best lesson I've ever learned is don't ever be afraid to say, I don't know. And there's still a lot of stuff I don't know. And where I'm asked a question and I have no idea about the answer, I say, look, it's a really good one. I don't know the answer yet, but I'll find out. And then I'll just go to someone within my network who knows the answer, and I'll get back. So take the step. You will make some mistakes. You will come across other professionals that don't meet the standards. Ask them to keep you up to date. I think it's professional courtesy. If you refer work to a lawyer or an accountant for one of your clients, ask them to keep you up to date. You need to have the up-to-date information on your file anyway, but it's just a professional courtesy. If they have a problem with doing that, then go and talk to someone else. Go and talk to someone who's prepared to meet your standards.
Yeah, and I think part of the I don't know response is what the AFAN community is all about. We don't have all the answers immediately, but we've got industry professionals we can go and consult with, and that's the way we interact with the clients, is to make sure it's a consultative process and we get the right outcome for them every time. Well, thanks, Craig. That was fascinating, actually. Again, the umpteenth time that I've seen it, I still look at those outcomes for the clients and go, this is a very powerful tool, looking back through the allocator there. We might go back to Georgia for questions from our attendees. Are you there, Georgia?
I am. Just hang on a sec. Hey, guys.
Hi.
Yeah, sorry about that Word document coming up before. We've had lots of really great questions, and I was just trying to collate some of them, and they kept popping up in the presentation screen.
Sure.
So yes, we've got lots of people on today. It's wonderful to see so many names and lots of familiar names there today. Some of the questions that have come up, some have probably been addressed, but Craig, probably one of them, what's the downside of getting a public trustee will?
Some people are forced to do that because they may have come to Australia from overseas and don't have any family. So they may be forced to do that. My understanding is the cost. It doesn't seem to be very clear what the actual costs are, and they think they differ in each of the states. But there is quite a heavy cost to the estate in the administration process. I think if clients are going to use the public trustee, they'll obviously get a very good job done during the administration process. I've never seen any advice documents on how wills should be structured come from a public trustee. But I think clients need to be aware of what it will cost the estate when the estate is being administered and what's included in that. And then they can make a decision about whether that's going to be value for money, or whether they want their families and professionals within their network to have a little bit more control.
So there was a similar question that came from Damien Eales. He was asking why solicitors actually do give a cookie cutter will.
Look, I don't know. I think you once again, it's no different, Damien, to our industry. Now, you look at our industry, we have sort of general practitioners that offer a bit of advice in a number of different areas. And we also have specialists. And I think most professions are like that. The legal profession is no different. You have, some, particularly the smaller suburban law firms that do a bit of everything. And if that particular lawyer is a little bit transactional, sometimes he or she may just do what they're instructed to do, and the clients don't know what they want. They don't know that there's particular or different types of outcomes. If Bob and Sue, the builder, walk into, you know, the Toowong legal office and or the Kenmore legal centre and talk to someone. They said, "Can you give us a will?" Sometimes they might just get what they're asked for. But it's really those who have the experience that will sit down with the client and start asking questions and start digging, finding out, you know, where assets are held, whether things like deeds of appointment have been done on particular trusts, whether binding nominations have been done on superannuation, what they actually look like, and trying to work out the outcome. So no different to our industry, mate. I don't know the answer. They're trying to make a buck, and perhaps they just simply don't have the expertise.
Another question from Damien, Craig, is that the child is entitled to the income. Is there a problem for the spouse spending this? Are there any restrictions?
No, there's not. Remember that the parent is the guardian and will be the trustee on the account, so he or she can have control of the account, and it's for the benefit of the child. I would never say never. There could be a problem if the spouse just went and put it all through the pokies. But realistically, that's part of our job moving forward with the widow and the family, is to help them manage that money. So if you've surrounded that widow with good professionals, then the money should be protected, and it's being used for the benefit of the child, for the ongoing costs of bringing up that child, to ensure that the child can remain in his or her school, continue to do his or her extracurricular activities. Once the child reaches 18, that child could get access to the funds, but remember that the pensions are designed to not only use the earnings of the pension account, but also the capital. And by the time the child is finally independent, the balance of the child's pension account is going to be zero or pretty close to zero. And I don't think, you know, any child who's had his or her education paid for, they've remained in their private schools, they've continued with their music lessons and sporting lessons and had a good, healthy upbringing, I don't think they're going to, you know, take any legal action against mum in that case. But, you know, never say never. It could happen, but it's unlikely to.
A couple of questions from Joseph Panthradil. Can these pensions, super funds to the children, be set up post-death, or does this super fund need to be set up before death, like a testamentary trust?
Look, it's supposed to be set up before. However, I have set up a couple for a couple of financial planners post a particular death. And the reason why we were able to do that is because we had the trustee of the super fund that gave us approval, and plus the widow. When we spoke about the particular strategy, we got written authority from the widow to actually implement it. So it wasn't, in both cases that we did this, they actually had binding nominations for pension accounts, but they were invalid because the nominations had expired. So in those cases, we were actually able to set them up post someone dying with expired nominations. That doesn't mean that every single institution is going to allow you to do that. But certainly, I would certainly put in a case study with approval and a signature from the widow or the widower to get that done. But it would come down to the trustees of the super fund allowing it to be implemented.
Another question from Joseph. If the income protection policy pays into Bob's family trust, will Bob be able to get a tax deduction on the premiums of the income protection insurance?
Well, if the claim is being paid into the trust, then the policy, the premiums will be waived for a start. But if the policy is owned by the family trust, that's his business, remember. So that'll be just seen as an expense of the business. But at the point of claim, if the benefits are being paid in, there's no premium anyway because they're being waived during claim.
one from an anonymous attendee. If a nuclear family of father and mother, both first and only marriage, have PAYG jobs, so they're not self-employed, and have children, is there any risk to them not having a will and dying intestate?
Just run that past me again, please, Georgia.
So a nuclear family, so a
Yeah.
vanilla style family, both in their first marriage with children and both PAYG jobs, is there any risk to them not having a will? So to them dying intestate, what
Intestate, yeah.
Intestate.
Yeah. I think there's always a risk in not directing where assets are going to go. If with basic Australian families, we often find that the house is jointly owned. So if dad passes away, mum is now the owner of 100% of the property and vice versa. But the issue is, or where the risk is in particular when both mum and dad pass away. Let's say they're killed in a car accident. And we have the family home, we have some insurance and superannuation proceeds that are just simply paid to the estate or whatever for the benefit of the kids. Now, who's the guardian? Who controls any of the accounts that have been set up for the children? But more importantly, at some stage, the children will enter into the relationship phase of their lives. So if mum and dad have passed away, and the assets have just simply ended up in the names of the children, then when the kids are in that relationship phase, they could be in a de facto relationship. We have the same problems that I spoke about before when the relationship breaks down. Assets are in the child's name. And when the relationship breaks down, if it's a son who's 20 years old and got a young girl pregnant, how much of mum and dad's, or the percentage that he receives of mum and dad's estate is going to remain in his name if that relationship breaks down. So I think there's always a risk. And I think any decent lawyer in the country will tell you there's always a risk of not having a will. I think every family should have a will so that they have control over the direction of their assets. And I think every family should seek advice from an estate planning lawyer and from a financial planner or risk advisor who has experience in this area, so that the assets that mum and dad are working hard for will only ever benefit those that they choose. Why allow someone else to direct this, and why allow other parties that you haven't even met possibly get access to the assets we've all worked hard for?
Agreed. And on that point, I guess another question from Damien. Do you get much pushback from clients on the fees you charge, given that we've just seen how much you've saved for them? I hope not, but what are your comments on that, Craig?
Yeah, zero, Damien. Never. And you're absolutely right, mate. The thing is that, you and I both have a lot of experience. We've spent a lot of time studying. We've got more study to do because of FASEA and the graduate diploma that we all have to do. But that's okay. We're just doing it, and spend a lot of money, getting to this level of expertise. And that's what they're paying for. It's the same when they're using a good accountant or a good lawyer. You're paying for the years and years of experience and expertise so that they can get the best outcome. And if a client is going to pay a couple of grand so that you can save the family a few $100 grand, it's never a question.
I think that's the main crux of the questions. Some of the other questions were a little bit similar in nature. So I might hand it back over to you guys and we can wrap up for today. We've got 5 minutes left.
Thanks very much, Georgia. And Craig, as usual, a very polished performance taking us through the allocator. I think it's so powerful when clients see that as to what it can mean to the family when something terrible happens. And it's always going to happen at some point in your life, so you need to be prepared for it. Next week, in 2 weeks' time, we're going to run another webinar. This time we're going to talk about financing and the industry, what it was like before Hayne Royal Commission, post Hayne Royal Commission, before COVID-19, after COVID-19, And in this declining interest rate environment, is it getting any easier to borrow funds? And what does that mean for the family in terms of leverage and so on? We'll go through some residential and commercial aspects. And also, as Craig eloquently put it earlier, what does that pokey habit mean to your continuous credit reporting file? So we'll look at some of the changes that have happened in that sort of open reporting space. Thanks once again, Craig, for your efforts this morning. This webinar will be on our website within a week or so if you want to go back and review some of the discussion points and have a look through the allocator again. But if there's nothing further, thanks very much. Thanks for joining us this morning to all the attendees.